Mr. Lanks.
Thank you, Your Honor. Attorney General, and this honorable court, it's my pleasure to appear before you on behalf of Mr. Lampkin. I represented him at trial. Mr. Lampkin was barely 15 years old when he joined a group of other young men and women. He was new to the area, having recently moved from Orlando. And in the course of the next several months, became associated with a number of burglaries, which I have highlighted in my brief and won't go through now. I will make the comment on these burglaries that there was no personal injury, and as I recall, minimal restitution. I was not the first attorney on the case. I got it when I was about a year old, and the strategy became quickly to try and work out some kind of an agreement. And the particular concern was saving this young man's record so he would not go into the adult world with a felony conviction. Over the course of 3 of our pretrial conferences that we have in the Sixth Circuit with regularity, there came a time, and the first one of which I speak, I think, was in September of 2016. There came a time when the trial court and the defendant almost were engaging one-on-one. And me, the trial counsel, felt fairly useless in that because they were making an agreement amongst each other. And the agreement which was made was that, and this also included the appellant's mother, was that if she would move him away from the bad influences and he would not have any more problems with the detention officers at the jail, that he would be sentenced to withholds on all the offenses and probation.
Now this all occurred before he entered a plea, correct?
That's correct.
And the transcript that I've reviewed, I'm not sure I agree with your characterization that you were standing there like a bump on the log, because it's clear you were engaging with the court, but then the court engaged with the mother quite a bit and was asking about the home situation and so forth. But didn't the judge indicate, look, you know, I'm willing to entertain an open plea. I'm willing to, I've looked at the PSI. You know, if we go forward with a plea, I can't promise you what I will do. I will take into account the PSI. I will take into account the information, but there are certain things you have to make sure and do, which is basically stay out of trouble. You're going to move away and so forth. So I'm not quite certain that the court said this will be, I mean, the way you said it, Mr. Likes, it sounded like the court said this is what you will get, and I don't quite see it that way.
Your Honor, I believe it at one point, and I thought that I quoted that. Perhaps I didn't.
Well, I've got the transcript in front of me.
Right.
Now the court says, and this is on page 9 of the transcript, if you entered an open plea to me, I've reviewed the PSI, I've reviewed the PDR, I have an idea of what I would do, but I also have a policy of not telling people exactly what I'm going to do, and otherwise we'll be playing let's make a deal. If I did, and this is what I think you were referring to, if I did place you on a period of probation though, if that was the decision that I made, you'd have to understand there'd be a number of rules, and then the court goes through that. So is there another point during the transcript where you think the court made it clear this is what he would get?
Yes, Your Honor. On page 112, I have quoted in my reply brief the court.
Hang on one second. So are you going to the hearing of October 21st now?
I think this was before October 21st, because in this...
So tell me the page number, the transcript page number, not the record page number.
I had it as record 112. And let me...
Because record 112 is the October, actually, let me go forward. Record 112 is actually the signature page of the court reporter.
I have record 112.
Well, but your belief is you're in the September transcript?
Yes.
Okay, so let me see if I can find where you are in that. Okay. Why don't you tell me what the judge says, and I will find it.
Okay. The court, that's what I was thinking, is if we were to come back October 21, and you had moved up to Holiday and had a new residence set up for him, and he were to enter an open plea to the court, comma, I'm pretty confident, provided that he hadn't gotten in trouble over at the jail, comma, that over the state's objection, I would put him on probation.
Okay. Now, this was before the open plea is entered.
That's correct.
And then they come back to court, at which time your client had already been accused of violating one of the conditions by throwing something on another inmate. And then there was the fact that his mom said they would be moving out of the neighborhood, so he'd have a different group of friends, which did not happen. So at that point, it seems the court says, you didn't abide by the things that you needed to abide to, you have a choice. You can go to trial, you can work a deal with the state, or you can enter an open plea, and the court seemed to make it pretty clear that if you enter an open plea, here's what you could be facing, correct?
Your Honor, I would respectfully disagree that the court made it clear to the defendant that he had violated. When I brought up the fact that first they presented this as him having thrown urine on someone, and Mr. Lampkin told me that what it was water, because the young man had been harassing him throughout the night.
Well, and I know you and the state disagreed on the sequence of events, which was information that you and the state presented to the court.
Well, but the court's comments, now perhaps they were sarcastic, but the court never really said, I find that this is what you did. I think he made comments like, oh, I'm sure you're not guilty, or awesome, and things like that.
But again, all of this was before your client entered the plea.
It was, but we have this record of no finding by him that these things really occurred.
Was there? I think I know the answer, but your client had an option, several options. One of which was to go forward to trial and to let everything come out. And I think the court said, I'm not going to swear to this, but I think there was something in there about, whatever comes out, and then you have your day in court language. So your client decided not to go with the jury trial. Your client couldn't work a deal with the state. And the third option was enter an open plea, and there are no promises.
That's correct, Your Honor, except for the one that I read at the end of the September hearing, and the fact that in this October, despite the fact that these potential problems came up, the court was caustic with this young man, but he never made a finding. And you've got a 17-year-old boy dealing one-on-one with the court. I was there. I offered, I believe I offered, let's have a hearing on that, because he, quite frankly, was in denial that there was ever any incident involving urine, so we're left with tossing water on somebody that's harassing him. I would have hoped that the court would not consider that so severe a misconduct to go from probation and withhold to 8 years. He skipped over youthful offender, Now, we're getting ahead of ourselves in the record, but that's where we were at this point.
Although at one of the earlier hearings, the court expressed some skepticism about the youthful offender. He didn't say he wouldn't do it, but he suggested, based on your client's record and the state's desire and the fact that he was 17, the court didn't seem to be terribly thrilled with the idea of youthful offender.
Well, and I attached these as appendices to my original brief. It's all the reports that were done by a psychologist, juvenile justice, and the probation, Department of Probation, Department of Corrections probation officer. They all said, send this kid back. So I was quite taken aback by that sentence, and I would respectfully submit that the caustic comments, the sarcastic kind of comments that were made when the court was presented with the potential misconduct in jail by the defendant, his mother said, no, I haven't moved. I couldn't break my lease, but it really shouldn't matter because all those kids are gone now. And there was no inquiry about that. Who are the friends? Where did they go? There was nothing, just a total presumption against the defendant. And of course, when he's pled, it's probably okay to do that.
You would agree that after the court went through, I think it was 6 cases that he had pending, and the judge went through each of the cases and what the charges were, and then the court, in the final colloquy, says, you understand by entering this plea you give up these rights. You could face up to 5 years in prison on each of the second degree, up to 15 years in prison, and he goes through all that. And then the judge says, by entering this plea today, I don't know what sentence I would give you. I'm going to give you credit for jail credit and so forth. I know the introduction of contraband took place later. I'm going to give you credit for that time in jail. But then he says, I don't know what sentence you're going to get. I could give you a youthful offender departure. I could sentence you back as a juvenile. I could give you 15 years in prison. I don't know at this time. If anybody's made you any promises as to the sentence, they're guessing. Do you understand that? Yes. Anybody forcing you to do the plea? No. And then the judge says, basically, are you sure you want to enter an open plea, right?
Yes, Your Honor, but please remember the judge is yet to say you did something wrong in jail after I said not to, and he didn't meaningfully respond to his mother saying, even though I haven't moved my address, the bad influences are gone. And also, please, if I may, Your Honor, put it into perspective into the whole time, and I hope this will show up in the record, I think it does, that through May of that year, he had a number of problems in the jail. And he was told that at that point, stop it. And he did. And
how many referrals did he receive while he was in custody? Was it 16?
I'm sorry, if that record shows that, then it was.
Okay.
I can't.
Here's how I see this. Tell me if I'm missing something. There was no motion to recuse this judge filed, correct? As a result of the caustic comments, you put all your eggs in the basket of vindictive sentence, right?
Well, yes.
So is your argument that there's a presumption of vindictiveness, or are you saying the record shows actual vindictiveness?
I would say both, Your Honor. Under McDonald, and I think a couple of other cases, when the court gets involved in the plea bargaining, that...
But who initiated the plea bargaining discussions? It was the defendant, wasn't it?
Well, it almost always is.
Okay, well,
but it's rare that the judge gets involved in it so much.
But in order for us to find presumption of vindictiveness, we have to find that the judge either initiated the plea bargain discussions or made a firm, non-moving offer. And everything that you've heard from Judge Silverman, I think your responses are consistent. There was no firm, definitive offer. Everything was precatory or conditioned upon certain events happening. And at the end, when the judge didn't impose what he thought he might, he explained everything away, which kind of goes against actual vindictiveness. If he wanted to be vindictive, he wouldn't explain anything. He would just go and impose a much harsher sentence than what he thought he might.
Your Honor, I would respectfully say that the passage that I pointed to on page 112 is a firm offer.
Okay, so it's a matter of interpretation.
Yes.
Okay, very good, thank you.
Mr. Likes, you're
Yes, sir.
a little bit over 15 minutes. I don't know if you want to reserve any time.
I
for
do.
rebuttal.
Thank you
Okay,
very much.
thank you, sir.
May it please the court?
Good morning.
Counsel. Michael Schaub on behalf of the state of Florida. Based upon the totality of the circumstances here, there is no presumption of vindictiveness. I believe, as Your Honor pointed out, this was a preliminary evaluation based upon circumstances that the defense brought forward to the court. And the court basically said, well, if these circumstances go through, I'd be pretty confident I'm amenable to that. Next pretrial date, those circumstances don't occur. And the judge, basically, you're back at square one. You have the right to plea, you have the right to open plea to me, you have the right to work it out with the state, or you have the right to go to trial. And the judge basically goes back to square one. And the judge even lets the appellant's counsel take another continuance because the appellant's counsel realizes that the circumstances have in fact changed. So another continuance to see what he wants to do. And that resulted in the final pretrial. I think if you look at the Wilson analysis on presumption of vindictiveness, none of those factors are met. First of all, this is not a retaliation or a punishment for the defendant exercising a certain right. This is not a situation like in many of these cases that you have a defendant coming up, rejecting a plea offer from the court, saying, I want to exercise my right to go to trial, going to trial, getting tagged for it afterwards. What you had here, it was a YO sentence he wanted. It's not a fundamental right to be sentenced to a youthful offender. It's not a right to have a plea bargain. If you look at the second factor in Wilson, you have the court is the one who's initiating the plea here. It's not the appellant's the one initiating the plea here, not the court. The appellant filed a motion for departure. The appellant comes in seeking a sentence back. When the state's not agreeable to the sentence back, he turns to the court saying, well, what about withhold and probation with a youthful offender status? And so you have the appellant initiating these proceedings. You also had the third factor that Wilson lays out is whether the court departed from its role as an impartial arbiter. I think nothing in the record indicates that. This is not like a strong-arm case where the court wants the defendant to plea or wants him to go to trial or tries to force him to do anything. The court is very matter-of-fact with what the defendant can do, gives the defendant time. As Judge Silverman pointed out, at that final plea, when he's about to enter the plea, the court goes, I'm not making any promises. Anybody who's telling you there's a promise on the table, they're wrong. And the court even gives the defendant time at that point to go talk to his mother, see what he wants to do.
But isn't it a little bit unusual to bypass the defense attorney and speak directly to a 17-year-old defendant to make all these snap-second decisions like that?
Well, the court allows, before the sentencing, for him to talk to his attorney. So before the colloquy happens, the court goes, okay, here's your 3 things you can do. Go talk to your attorney, see what you want to do.
And did he ever acknowledge, I spoke to my attorney, discussed all the options, and upon advice of counsel, I'm entering this open plea?
I don't think he says that specific.
Well, I mean,
but
that would be a rational answer.
He's decided to enter an open plea. Because the counsel asks, what's the best offer from the state? State says 9 years. Counsel goes back, talks to him, comes back, and he decides to enter this open plea after talking to counsel. So there is indication that he's spoken to counsel about this decision.
And what's the most he was looking at, 40?
The most he was looking at, the maximum on the guidelines was 71 years, Your Honor.
Okay.
And as to the last facts, the lack of facts and circumstances change. As I said, you had circumstances being presented to the court about this is what is going to happen. When the court gives this preliminary evaluation, these things don't happen. And the disparity between the offered and ultimate sentence, I don't believe there was ever a firm offer. This was a preliminary evaluation done by the court that was contingent on certain circumstances that never came to fruition. And if the only offer that was actually on the table was the state's 9 years before sentence, and the defendant got 8 years. So based upon all these things, Your Honors, I don't believe there's presumption of vindictiveness, much less actual vindictiveness in this case. And for all these reasons, I'd ask this court to affirm the sentence. Thank you.
Thank you, Mr. Schultz. Mr. Lights?
Thank you, Your Honor. On page 119 of the record, starting at the top, the court, he got a new charge while he was in custody, or he was fighting, or Mr. Likes. I mean, it sounds like there are two very different views on that. The court right, Mr. Sarabia, well, and threw urine on another inmate. I don't even think he's been charged for that. The court, it doesn't matter. There's been additional allegations. So yes, Mr. Likes, he says it's not urine. The court, I'm sure he's innocent, okay? So what are we going to do? Mr. Likes, well, his juvenile probation officer is very confident that the right thing to do is to sentence him back to juvenile. The court, awesome. Now, the appellant would respectfully submit to this court that presumptive vindictiveness, and believe me, I like Judge Syracuse. I always put in the briefs when I talk about vindictiveness that I hate to have to use that word, but that's what North Carolina versus Pierce says we have to use. But I think they create presumptive vindictiveness from the fact that the court was involved in the plea bargaining. And this passage I just read to you either says that the court doesn't believe Mr. Lampkin did any of that stuff, or if he was speaking in a caustic and sarcastic manner, I believe we have actual vindictiveness.
Mr. Likes, which hearing was that? Was that the September hearing or the October hearing?
It was October 21st.
And the actual entry into the plea was was a month later at the November hearing?
Yes, Your Honor, that's correct. And I would also respectfully request that this court consider that jumping from withholds in probation all the way to 8 years for such a young man at such a time in his life is also demonstrative of vindictiveness. You didn't do what I want, so you're gonna pay the price. And I respectfully submit that that's an appropriate way to look at this. It's supported by the record, it's supported by what happened, and it's not right. And I would like this court to do what, I'm sorry, I can't say which cases right now. Sometimes the appeals court has just gone ahead and entered a sentence, or suggested a sentence and sent it back to say, enter this sentence. But in this case, I would primarily ask that it be sent back to be sentenced by a new sentencing court. And as a matter of fact, there's a new court in that division, which would be Judge Kimberly Campbell, I believe. And I think that would be a just result in this case. And I think it's supported by the record, it's supported by the evidence, and it's supported by the case law. Thank you very much.
Thank you, Mr. Lights. Thank you both.